The Honorable Presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. Court of Appeals is now in session. I'd save the state and its honorable court.
Good morning and welcome to the North Carolina Court of Appeals. We are pleased to be able to have this session of court today to be able to hear one case. On behalf of Judge John Tyson and Judge Electra Collins, I welcome you to this court session. The case for oral argument today is Home Realty Company and Insurance Agency versus Red Fox Country Club Owners Association, Inc. We will hear from the appellants.
Good morning. Thank you, Your Honors. I'm Fenton Irwin, and I appear as counsel for some of the 200 defendants in this case. I practice law in Charlotte, North Carolina with the law firm of Irwin, Bishop, Capitano, and Moss. There are separate stories of each of the 200 defendants in this case as to what led them to purchase the real estate in Red Fox Country Club in Polk County, North Carolina. While the 200 or so defendants may have a separate story, there is a shared story, a common story that each defendant possesses and that each defendant possesses and shares with another defendant. Each of the defendants believed and acted on the truth of representations made by Home Realty and its predecessors before purchasing the property in Red Fox. These representations were made orally, they were made in brochures, they were made on maps and plats, and the reasonableness of these representations were strengthened by the existence of the golf course and its amenities, which were already physically located on the property. As an example of these representations, I would like to refer you to record page 113 for one of the glossy brochures that was used during the presentation of the property to a multitude of the property owners that are the defendants. Some portions of that highlighted portion reads, all development will be strictly controlled by covenants, restrictions, and architectural reviews. The entire community has been planned in advance, so you know exactly what your club will be like in the years to come. Because Red Fox is a complete country club, you'll enjoy your favorite forms of recreation right in your own neighborhood. Now, the truth...
Excuse me, sir. Could you please tell us the time frame of this particular brochure and when it was used?
It was used according to the affidavit of Tony Jackson, which was in the record. Tony Jackson was a professional golfer who was also in the sales for the Home Realty Company, the plaintiff in this lawsuit. And he avers in his affidavit that these brochures were used during the course of his presentation and that of the owner in making presentations to the property owners, potential property owners.
And about what time frame, sir?
Well, he was there during the time that shortly before the time that Home Realty purchased the property, and then was there after Home Realty purchased the property and served as a professional golfer and teaching lessons and so forth there for a goodly number of years, as set forth in his affidavit. This example of a representation and other similar representations was shattered when on November the 4th of 2018, Home Realty shuttered the golf course and posted no trespassing signs on the property, denying to these 200 plus defendants access to the Red Fox property. So instead of having the beautiful lake and the free flowing streams and luscious green areas, plaintiff Home Realty has now left these 200 plus defendants with unsightly overgrowth of all of the grounds, the decimation of lakes and streams, and wild animals actually roam this area now. In the brief time that I have this morning, I would like to tell you our position and the reasons that we believe that the trial court's order and judgment should be reversed. Plaintiff filed a motion for judgment on the pleadings along with a brief and exhibits that were filed. Some of these exhibits were outside the record, that is outside of the pleadings, such as correspondence and assignment of development rights, even pleadings in an unrelated lawsuit involving the parties, some of the parties, and including a copy of an unsigned consent order that does not bear a file stamp. The defendants filed a brief in opposition to that motion for judgment on the pleadings, and they also attached affidavits and exhibits to that memorandum of law. In doing that, the defendants asked that the court treat the hearing on the motion for judgment on the pleadings as a motion for summary judgment. In the case of Minor versus Minor, 70 North Carolina Appeals, at 70 North Carolina Appeals 76, a 1984 case, the court stated that when a motion for judgment on the pleadings is filed, no evidence is to be heard. The trial court is not to consider statements of fact in the briefs of the parties, nor the allegations of the parties in different proceedings. And the court basically said that, Court of Appeal said that you're to look at the pleadings themselves and nothing further. The court went on to state that in this particular case, in the Minor case, when the trial judge considered the pleadings and the attached affidavits and also heard counsel and considered briefs that were submitted by both parties, the motion must be considered as though it were made under Rule 56 for summary judgment. And that's the position that we take, is that the court, in effect, ruling on the motion for judgment on the pleadings, in effect, making a summary judgment decision.
I have a question.
Yes, ma'am.
So when I read the order granting judgment on the pleadings, the trial court specifically says that he considered, or it considered, quote, the pleadings, the arguments of counsel, and applicable law. And those are the specific things that a trial court can consider. And don't we look at the language of the order to determine what the court considered?
You're exactly right, Your Honor. But in the order, it also states that the parties had previously agreed to a briefing schedule and had submitted extensive written materials to the court for the hearing. And so it's not stated that the court ruled on the pleadings exclusively, and it had before it, at the time that it ruled, it had all of the exhibits that had been submitted by each of the parties. So the implication that we draw from that is that although it's not specifically stated implicitly, the court did decide based on all of the materials that were before it.
But the court can consider the memorandum of law, correct? It just can't consider affidavits and whatnot, correct?
Well, I believe a strict reading of the minor case that I quoted, the 1986 case in 70 NC Act, if you strictly were to read that case, it indicates basically that the court is to limit its decision to the pleadings itself. And there's even language in that case that you could construe as meaning that there maybe shouldn't even be arguments on the motion. Although
we've got I think we've got a lot of cases that have said that memoranda of law are the arguments of counsel that indeed can be considered on judgment on the pleadings.
Right. Well, if you assume that, and I'm certain that that's correct about the memorandum of law, that anything that is outside of the pleadings is not appropriate to consider strictly in a motion for judgment on the pleadings.
Correct. So my question is, by specifically stating what the trial court considered, doesn't that exclude those documents that it could not consider?
Well, but it doesn't explicitly say that it did not consider the extensive documents that had been presented to it, which it had at the time of the hearing.
True, but doesn't our case law say that we can look at what the trial court considered, and by virtue of the fact that it did not consider things outside of the pleading, that language suffices?
Well, I would urge the court that in the absence of express statement that the court did not consider anything outside the pleadings, that the implication from the order is that it did consider it, although not explicitly stated in the body of the order.
Okay, thank you.
Mr. Earl, I have a question. If there are exhibits attached to the pleadings, are they not considered part of the pleadings themselves?
I think they are, yes, sir, particularly contracts and things of that nature. No question about that being part of the pleadings. But in this case, there were submitted by the plaintiff, there were copies of pleadings in an unrelated case to the case at bar, which the minor case says are not to be explicitly says are not to be considered.
Going back to Judge Collins' question, can you point us to anything in the order that showed that the trial court went outside the pleadings and issued its ruling?
No, so there's no affirmative statement to that effect in the order, but I'm urging the court to consider the fact that it did state that the parties submitted extensive written material to the court prior to the hearing. And if it were limiting itself only to what the pleadings and the attachments that were proper, then it would not have added that statement, we contend. In fact, there were those explicit documents that were attached, including affidavits. The Capstone Development Company acquired all of the Red Fox property on October the 4th of 1983. And Capstone Development gave to Adrian Hooper a deed of trust that was filed on June the 27th of 84. Now, at the time of the filing of that deed of trust, and at the time Capstone Development acquired ownership of the property, there were 70 lots or tracts of land that had been previously sold by the developers of the property. Those 70 lots that had been previously sold were unaffected by the Hooper deed of trust whatsoever. On December the 23rd of 1986, the restrictions that we're referring to in this case as the 1986 restrictions were filed by the then owner at Red Fox, and the golf course property, the 230 some odd acres of property, was included within the legal description of the property described in those 1986 restrictions. So of the 70 lots that had been sold, there were 40 property owners that owned property before the recording of the restriction that signed and recorded ratifications which adopted and imposed upon the property that they had bought the requirements of the 1986 restrictions. So when the Hooper deed of trust was foreclosed, the foreclosure did not affect the 70 lot owners, nor did it affect the 40 tracts of land whose owners had ratified the 1986 restrictions. Now, the 1986 restrictions provide that they run with the land. That's at record page 442. It's difficult to read on the exhibit that we're putting to the court, but it's part of Part 5, Roman numeral 5, Article Roman numeral 2, Section 1. The restrictions run with the land. In Section 4, record page 445, the restrictions provide that they're enforceable against the owner, its successor and assigns, and others. So the conclusion as a matter of real estate law is that the 40 ratifying property owners and their successors in interest possess rights to enforce the 1986 restrictions as against each other and also against the plaintiff, because the golf course property was a part of the legal description of the property in the 1986 restrictions, and those restrictions run with the land and don't run, they're not personal restrictions. This conclusion as to the validity of the 1986 restrictions as to the 40 property owners exists without regard to the issue of whether the Hooper deed of trust foreclosure extinguished those 1986 restrictions. So we're saying that there are two issues, one that relate to the 40 property owners and one that relate to other and subsequent owners. For these reasons, we're saying that the trial court committed reversible error in determining that the 1986 restrictions had been extinguished as to the 40 property owners and their successors who signed and recorded the ratifications. The trial court also, we say, committed reversible error when it declared that the 1986 restrictions were extinguished as to the 231.20 acre tract, the golf course property, that was owned by plaintiff, because the 40 ratifying property owners and their successors in interest possess rights under the 1986 restriction to that golf course property. Now, moving to the foreclosure of the Hooper deed of trust itself.
Before you go there, Mr. Irwin, I have a question.
Yes, sir.
Would the effect of whether or not the 86 restrictions survive the foreclosure, would that be a question of law? Purely a question of law?
I believe that it would be a question of law. Yes, sir, Your Honor. There are not any facts. I don't believe. The only facts would be who would be affected by the decision.
Okay. Thank you.
Yes, sir. The record page 544 through 546 deals with the habendum clause in the Hooper deed of trust. And that habendum clause says that upon default, it's the duty of the trustee to sell the land after having first given notice of hearing of the commencement of the foreclosure, as may then be required by law. So the trustee had a duty to meet the legal requirements for notice. We challenge the fact that there was no notice in accordance with the statute. The then existing statute in 1990 is a part of the record at page 1085. It's a statute, NC Gen Stat 45-21.6, and the 1986 restrictions created Red Fox Country Club Association that's a party to this lawsuit. And the restrictions provide that every property owner within the Red Fox development is a member of that association. The restrictions also require that the owner transfer ownership of the amenities and the common areas, the open space, including the golf course, to the association no later than January 1 of 1996. The foreclosure occurred in 1990. So at the time of the foreclosure notice, the association that was created by the 86 restrictions and its property owners possessed a future interest to have that property conveyed to them. The statute itself defines to whom the notice is to be given as an owner and defines the owner as one that includes a party who possesses a future interest. Our position is that the parties possessed a future interest in that property and that notice was required to the association. It's interesting for the court to compare the notice that was given in the foreclosure of the North Carolina Federal Savings and Loan Association, because the notice from the trustee in that instance under the same statute said that it had been given to the property owners, landowners, I think is the word that was used, to the association and to others. So we're saying, of course, that the court can take judicial notice of the fact that when a foreclosure sale is in a chain of title, the attorney searching that chain of title has to determine the validity of that foreclosure in order to certify title to the owner in whose chain of title that foreclosure exists. We contend that we had a future interest in that property, that notice was required, and we've given the examples in the case of those instances in which notice was not given. Judge Tyson was on one of the panels in the Hinkle case, I believe, that found instances that avoided the normal priority of cases, the normal priority of documents, normal priority of recording in order to achieve fairness and equity. I'd like to reserve the rest of my time for.
I have one question, Irwin, if I may, before you go. Did the savings and loan, the lender, did they acquire, was their lien in the deed of trust, did it have priority over any interest of the lot owner?
I'm sorry, Judge Tyson, I couldn't understand exactly your question.
Did the deed of trust that was given to the savings and loan, did the lien in that deed of trust, did it have priority over any rights of the lot owners?
Well, it certainly did. All of those lot owners that purchased after the property, after the deed of trust was recorded, would have been affected by the foreclosure.
Right. So is the interest of the lot owners more of a contingent interest that arises if it arises by conveyance in 96? Or I'm trying to figure out what under the statute would require them to have notice if their interests were subordinate to that of the deed of trust.
Well, the foreclosure required notice of a future interest, and at that point, before the deed of trust was foreclosed, every member, every lot owner, every property owner, regardless of when it had bought, was a member of that association. And at the time of the foreclosure, before the foreclosure, there were each of those, the association was to have been acquired, was to have been delivered title to the property. So each individual property owner would have been benefited by that transfer, regardless of the.
You're saying that it's not a mere contract right then. It's a right that ran with their property as opposed to giving rise to a breach of contract action.
It is. It's a right that ran with the land that is established in our real estate law. Yes, sir.
Thank you.
I'd like to reserve the balance of my time for rebuttal.
Certainly, sir.
Thank you.
Hear from the appellee.
I can't hear him.
I'm sorry. We will hear from the appellee.
There. Now, hopefully you will hear from the appellee. I'm Robert McNeil. I represent the plaintiff appellee, Home Realty. My partner, Amy Hunt, is here with me, and I understand that the principal of my client is also observing. I think it's commonly known. Well, let me start with something else. There's a lot of talk about the summary, whether this is a summary judgment or a 12B6 motion, and there's when we submitted our orders to the court, competing orders were submitted, and Mr. Irwin submitted an order that asked Judge Irvin to say that each exhibit submitted by each party had been considered as part of granting the 12B6 motion. And the judge refused to sign that order and instead signed the order that we submitted that, as you pointed out, says considered the pleadings. I believe pleadings, arguments, and law, I believe is what it said. So I want to point that out. Now, it's commonly known that golf is a sport in decline and that there are a lot of courses that are in financial trouble. And for the past decade, hundreds of courses have closed every year. And that, of course, is understandably concerning to the folks who live near those courses, and it often leads to litigation. We've seen a lot of that over the past several years. But in North Carolina, we've been very insistent that people who buy real property should be able to go to the public record and determine from the writings contained therein who has what rights regarding that property. And the few exceptions that we have to that rule are very narrow and very clearly defined, and this situation does not fall within any of them.
Mr. McNeil, how would you characterize the defendant's interest in the common areas of the golf course and lakes that were adjoining and represented on the brochures?
Well, I do, based on the Seashore Properties case that we cited in our brief, I don't think that they were of the type that were where they were required to get notice under the foreclosure statute.
Did you have an expectancy or a contingent future interest? I mean, we've got to determine what the nature of their interest would be. Do you agree with that as a matter of law?
Well, I didn't think it was so important to put a name on it. To me, what seemed to be important was to decide, first of all, if they were required to receive notice under the statute.
Wouldn't that be necessarily dependent upon their interest, whether or not they were entitled to notice?
It would, and what I would say is it's similar to the type of interest that was available, that was the concern of the Seashore Properties case that we cited in our brief, in which the court decided that those folks, whatever that interest was they had, I don't remember what they called it. They may have called it a future interest. I don't remember, but it was, they were not required. They were not a party required to have notice.
So are you saying that the lot owners had the same status as a stranger to the title, or any interest to the amenities that were represented in the brochures when they bought the lot?
Well, I think our case law is clear that the brochures don't create any property interest. But I don't I just, to me, the question I kept focusing on, and if I focused on the wrong one, I'm sure you'll tell me, but the question I kept focusing on is there anything in this statute that required them to get notice, and can the defendants complain about that, over 30 years later, when the clerk determined as part of the foreclosure that everybody who was entitled to notice received it?
Now, we do have case law that says that there is no statute of limitations to challenge a foreclosure if you were supposed to have notice and didn't. Am I correct about that?
I believe that the statute that was in effect at the time of this foreclosure maybe had a 6-month limitation on it.
So there's no, your contention is that the statute ran, regardless of whether they're entitled to it or not, it doesn't matter at this point.
That's right. I just think, I would think, when I think about all the statutes of limitation that are in the North Carolina jurisprudence, 10 years is about as far out as you ever see for anything. I don't know of any that's more than 30 years, which is, what we've had here since this foreclosure took place. My client would want you to know and remind you that it was not the developer of this subdivision, that it bought a failed business from the Resolution Trust Corporation as part of the savings and loan issues in 1992, and for years it subsidized a golf course that the residents didn't want to support and still don't want to support, and they bought the property based on a search of the public record that showed there were no requirements that this land be used as a golf course. Now, it is true that the 1986 restrictions contemplated a regime or a method of operation in which the lot owners would regularly pay all the cost of operating the golf course, and at a certain time, no later than 1996, the golf course would be conveyed to the HOA. Now, we're saying two things about that. Of course, one is those restrictions were wiped out by the foreclosure, and the second thing is that even if somehow they weren't, it's way too late to sue to enforce any provision under to transfer the property, given how long it has been since 1996. There's been some talk about the condition of the neighborhood, and I just want to say, my client has a bigger financial stake in this neighborhood than anyone. In addition to the golf course property, it still owns a number of platted lots. So to suggest that my client has taken some action to deliberately harm the neighborhood is not accurate. There's nobody who has more at stake in the success of this neighborhood than my client.
So I have a question. You have argued that there's nothing in the 1986 restrictions that requires this land to be a golf course, correct?
That's correct.
So what restrictions is your client attempting to remove by declaring that these restrictions don't apply? What is it about these restrictions that would inhibit your client from doing something with the land?
There is well, first of all, I would say there's not anything, but some people who read them become concerned. And I think the things that concern are the conveyance rights in the future, the fact that you know, the problem is often when a golf course gets closed, there's litigation, and buyers don't want to buy a lawsuit. And while I, as a litigator, can look at those restrictions and say they've been wiped out and there's nothing on there that you need to be concerned about anyway, I think that folks who give title opinions and write title insurance are necessarily a lot more cautious about that. And if they put their name on the opinion and say, you don't have to worry about these restrictions, and then there's litigation, it's you know, their name on the line. So, you know, to me, this lawsuit is brought out of an abundance of caution. That's a long document, and there are a lot of creative lawyers. And I think what we're trying to do is just be absolutely clear that nobody's ever going to be able to find anything in that document that they're going to be able to use to try to stop future development.
Do you agree, Mr. Neal, that surely restrictive covenants have been construed to run with the land?
Yes, I think that if these covenants had not been wiped out, that they would run with the land.
Well, if they run with the land, don't they generally survive foreclosure?
No, absolutely not.
If there are other interests, well, you would agree that if there were other interests that were not going, then they would not be affected by the foreclosure. That's another one of Mr. Irwin's arguments, correct?
Look, no, I disagree. I disagree very strongly with that argument. I get that there may be some lot owners out there who were not subject to the Hooper Deed of Trust, who may still have, whose lots may still be encumbered by these restrictions. But I don't agree for a minute that they have the right to enforce those restrictions against the former golf course property, because our law is clear that title acquired by foreclosure relates back to the date of the mortgage to cut off intervening equities and rights. And the foreclosure cut those rights off as far as the golf course property goes. Now, fortunately, we don't have to litigate. We're not here to decide today about the rights of the lots owners between themselves. The other thing I'd point out is I can't tell from the record which of the tracks are the ones that are not affected. I don't even know if any of the represented defendants are those people. So
you're referring to the 40 lot owners that were in place prior to the Hooper Deed of Trust.
right.
So you don't know that any of those 40 lot owners are parties or defendants in this litigation?
I can't tell. Now, I'd say the odds are they probably are, but I can't tell from the record which ones.
But you don't think their rights are any different than the other lot owners?
That's exactly right. I think what we look at is that the foreclosure made title to the former golf course property the same as it was the date the Hooper Deed of Trust was put on record. And that was free and clear of any restrictions. Not any restrictions. The 1966 restrictions are still in effect, but free and clear of the 1986 restrictions.
Thanks, thank you.
All right. So I don't have maybe I don't have a lot of imagination, but it seems to me that perhaps since this was a judgment for a motion for judgment on the pleadings, perhaps what I should do is talk about each of the claims that were not abandoned by the appellant very briefly, and talk about why Judge Irvin's ruling was correct. And obviously, if you guys think that is not a good way to proceed, I'm sure you will let me know.
I have one question before you go there.
Yeah.
Is your position that even if Judge Irwin went outside the pleading and considered the other data, that his orders should be upheld even under Rule 56 because there's no genuine issue of fact?
Absolutely.
So under either 12C or Rule 56, you're contending that his ruling was correct.
I do agree with that. I don't understand. I'm a little confused as to why it's so important to the defendant appellant that it be a call to summary judgment motion rather than a 12B6. I do believe it was properly treated as a 12B6, and I do believe that Judge Irvin was right to decide it under Rule 12B6, and that the order indicates that he did it the right way. But I think that if the court were to determine that somehow we crossed that threshold and got into considering things that shouldn't be considered, that the order could also be upheld under Rule 56. So we only have one claim, and that's our declaratory judgment claim. And I don't believe that the defendants have taken issue with the law that title acquired by foreclosure relates back to the date of the mortgage so as to cut off intervening equities and rights. I think really all they've said about that is to apply that law would be inequitable. Their biggest argument was the notice argument. And I think we've gone over that a bunch, and we've gone over it in our brief. We showed up this, we talked about the Seashore Properties case. I also want to talk about the burden of the clerk. The clerk has to decide as part of the foreclosure hearing that everybody entitled to notice has received notice. And I got to say that if what Mr. Irwin says is correct, probably every foreclosure in a subdivision in North Carolina in the last 30 years has been defective, because it's not the practice of foreclosure attorneys to notice everybody in a subdivision who is subject to a restrictive covenant. And think about the burden on the clerk. The clerk has the job of deciding whether everybody entitled to notice has received notice. That's one of the things they determine in order to allow the foreclosure to go through. Think about in this case, I mean, I'm here to tell you, it was a job to figure out who the defendant should be in this case. And it took a lot of time to get it right, and it took a lot of time to serve it. And if that has to happen in every foreclosure case, in order to have an effective foreclosure, those matters are just going to grind to a halt.
Mr. McNeil, you do agree that a foreclosure of an individual lot in a subdivision that's subject to restrictive covenant do not void the restrictive covenant. You agree with that? If they were recorded prior to the mortgage.
If they're recorded prior to the mortgage, I do agree with that.
Okay, and you do agree that these restrictive covenants were recorded prior to the date of the deed of trust, the lien on deed of trust, correct?
That is not true. These restrictions were recorded after the Hooper Deed of Trust.
All right, so the only restrictions that were in effect are the 1966 restrictions.
The 1966 restrictions are still in effect.
Right, and you're not contested with the validity of that.
That's correct.
Thank you.
Uh-huh. So I believe I've addressed the I believe I've addressed our claim pretty well, and I'm sure if there are other questions, you'll let me know. I guess the other thing I want to talk about are these brochures, the marketing. We have the Friends of Crooked Creek case that Judge Tyson authored, and I don't want to presume to tell him what it says, because he probably knows what it says and what he meant. But I do.
Was there a HUD disclosure done on this subdivision? Was this considered a resort property that was subject to a HUD disclosure?
I don't know the answer to that. I have never seen one in all the documents that I have looked at, but I can't tell you that I know that for sure. But it is true that this property was marketed as a golf course subdivision, and of course, people, my clients wanted it to be one. It would be very nice for everybody involved if that stayed viable. But the Friends of Crooked Creek case has made it clear in North Carolina that we don't rely on those marketing documents to create an enforceable restriction. Any restriction that is going to be enforceable has to appear on the public record. And if marketing materials could create enforceable restrictions, the job of title searchers would be very difficult, because for obvious reasons. Another argument that is made is that there is some easement created by plat, or an easement to the golf course implied by plat. And I think we've addressed that very clearly. The plats appear in the record at page 673 and beyond, and they do not describe the golf course with sufficient particularity to serve as a valid description in order to convey rights in that property. And the Crooked Creek case addresses that. There's a case called Steins that we cite in our brief that addresses that. There are some more complete plats that appear in the record, but please note that those plats were never recorded, and property was not conveyed by reference to those plats. There's some talk about there's an estoppel argument, because based on the fact that when people would buy lots, they would ask the owner to sign a document specifically waiving a right to repurchase. That right to repurchase appears in both the 1966 restrictions and 1986 restrictions. The suggestion was that by signing those waivers, that somehow people were misled. But I would point out that, first of all, the waivers did need to still be signed because of the 1966 restrictions. And secondly, there's no time when my client attempted to enforce its right of repurchase on the 86 restrictions. it has been trying to get rid of lots, not acquire them. And it has never taken any position in one of those waivers that is inconsistent with its belief that the 86 restrictions have been cut off. They merely signed those as accommodations to the understandably cautious folks who were certifying title for the buyers. This has been a long road for my client. My client would like to have this issue resolved. My client would like to have this issue resolved in its favor, so that this golf course land can be sold and put in the hands of someone who can put it to a productive use, which is both consistent with North Carolina law and will be an asset to this neighborhood. Certainly an improvement over what's happening now with a vacant golf course. So I thank you for your attention, and I'll be glad to answer any other questions that you have.
Sir, opposing counsel had cited to the Sear case in its brief. Could you please discuss the Sear case with us?
I'm sorry, which case?
The Sear case.
Okay, I'm going to have to refresh my recollection about which one that is, but if you'll give me just 1 second, I will do that.
All right, sir, it's on page 24 of their brief.
Okay.
It was basically in response to creek analysis.
All righty. Yes, the case about the lake. Yes, so the big difference in that case is, to me, in any event, the big difference in that case is that lake was fully shown on the plat by which lots were conveyed. So when you looked at that plat, there was no question about what land was being encumbered. You could look at that plat and see the full extent of the you could see the full extent of the lake on the recorded plat, and that's the primary difference between that case and our case. And in our case, well, first of all, you know, we've got restrictions that we say were wiped out, but secondly, as far as the plats go, if you look at our plats, which begin at 673, the golf course is very lightly shown on the plats. It mentions some holes, but there are no dimensions. Nobody could look at those plats and determine the location or extent of the golf course.
All right, sir. Thank you.
You. Is there anything else?
I just have a follow-up on that. So when we talk about, in the Sear case, it showed the entire lake. In this case, the plats, maybe they reference a hole 11 or they reference a hole 2, right? It was part of the golf course. Is that sort of a way to get around making sure that there's no dedication by plat? We should put all of these different deeds and plats together, that we have an entire golf course.
Even if you put them all together, you wouldn't. It would not be sufficient to draft a legal description that would be sufficient to convey an interest in the golf course. The information is just not on there. Now the lots are clearly drawn. You can see that they have meets and bounds descriptions on them. They close. Their entire boundaries are shown. The golf course is very nebulous. The lines are dotted, and on some there are no lines at all. Like on the plat for section E, it shows holes behind the lot, but it shows no boundary at all for the golf course. It looks like it goes on forever. So these plats just weren't drawn sufficiently, with enough detail to allow for an effective description of the land that would be affected by the plat.
And just a question, is there any legal, I guess, meaning behind the dotted line on the plat versus a solid line, other than not surveyed?
That's right. Generally, dotted lines have not been surveyed. They're shown. They're really sort of at the discretion, I guess, of the surveyor. They might be out there because they think that's where a line is, or they, maybe they see something visible out there that leads them to believe that's an approximate place where some change takes place. But you're right, there's not a survey in association with that line. That line is not specifically located on the ground.
Anything further?
I have one question. With the lot owners who join the lake, would there be an abutter's right of access to the lake on the common law by virtue of having property that is joined the lake or body of water?
I don't think so. There has been a subsequent document where it's been agreed that that my client has control of the lakes. So I think that document is the one that would control. I don't remember exactly what it says, but I know there is a document that deals with rights of the lakes, and it's a document that's been done, I believe, this decade. I mean, it's not that old.
So you would think that any party that has property adjoining a lake would be party to that agreement. That's the.
That's what I believe. Yes.
Thank you.
Anything further? Thank you, sir.
Thank you.
Rebuttal, sir?
Thank you very much. There are several things that I wanted to bring to the court's attention. Contrary to what Mr. McNeil said, the owners of the property support and want to continue the use of the golf course. That's why they are forming a defense and are making our case to you. And secondly, the defendants include some of the property of those 40 property owners and their successors as well. Judge Collins, you hit the nail on the head with your question about the fact that if there's no easement asserted in the restrictions, then what's the big deal? I mean, why provide a lawsuit? And the reason is that there is a serious title defect. The title defect is this foreclosure that we've been discussing. That notice requirement is a due process issue. And don't you know that if there were a statute of limitation that would bar any of those lot owners from asserting that lack of notice, that a title insurance company would have insured around that objection or even made it as an exception? That's really what this case, I believe, is really about at its meat, in that there is this title defect, and that's the reason for the lawsuit, and it revolves around that notice issue. I want to also address your question, Judge Collins, because I thought it was an excellent question. You know, when we have contracts, there's a statutory requirement, a statute of frauds that contracts to buy and sell real estate can be, must be in writing, but yet we allow different writings to form a basis for the contract where those writings combine to show what the intention of the parties are. So we argue to you that, yes, we believe that those plats can be put together in such a way as to show an intention on the part of the developer. There's a uniform plan of development here. I also wanted to deal with I'm sorry, before I go, with the due process issue, this notice of taking a property interest without the notice is a right. And there's no more interest than the individual property owners have collectively. The collective interest of the property owners, these 200 plus property owners, far exceed the interest of the plaintiff in this case. These property owners have invested their lives and their families in the property here. And we urge the court to consider our arguments in that regard. I wanted to point out two things. Judge Tyson.
Before you leave that point, I'd like for you to respond to Mr. McNeil's argument that part of what the clerk must determine at the foreclosure hearing that all parties who are entitled to notice have been joined for foreclosure, and the fact that 30 years has gone by since that determination was made.
Well, it is true that the clerk is to require, and at this time, the statute identified those factors that the clerk had to determine. But the clerk, in this instance, didn't get it right. And there have been people whose due process rights of notice have been affected by it.
Let's say we agree with you. How do you respond to the passage of time, 30 years?
Well, I don't think that it has any relevance to the issue of the rights of the property owners. They still exist. They haven't been extinguished. And that's the reason or underlying reason for this lawsuit.
Even adverse possession would run after 21 years. You do agree with that?
Yes, sir. I mean, I know that it is, that does apply, but that hasn't been asserted as a defense or bar to the notice requirements. Adverse possession doesn't deal with the constitutional due process issues. These property owners were identified. Mr. McNeil's statement about the subdivisions and notices is off base in that here we're dealing with owners who had property interests as a future owner who were entitled to statutory notice. That's the argument that we make. And I would like to address.
Were there all the defendants that were currently defendants in this case, were they originally joined into the declaratory judgment action, or have others come in since then?
I don't know the correct answer, but I do know that Mr. McNeil has made an effort to add new parties that have come that we've been aware of. But I don't know, we haven't been up to check the public record in the last month as to whether any additional parties should be added. But my belief is that there are probably not any, because when the golf course, when they shuttered the golf course, nobody wanted to buy any property up there anymore because it's not a golf course community. And so the sales were few and far between, as I understand it.
I know you have another argument to make, but I do have a question about the restrictions. Are you asserting that these restrictions require the golf course property to be maintained as a golf course in perpetuity?
Yes, we are. And we're doing that for several reasons. One of them is that the real estate that eventually became owned by Home Realty, the plaintiff in this case, was described in the restrictions. So that property was in the restrictions, and it runs with the land. It's not the owner of the property who's affected, so that when Home Realty bought the property, it bought it subject to those 1986 restrictions, because there are 40 individual property owners and their prodigies, their successors in interest, who still have an interest.
So what happens when a property owner can't maintain it as a golf course? Golf courses are expensive, people stop playing. Then what?
Well, that's an issue that would have to be determined. And of course, if there's a determination that it's an easement, there are several cases in the Court of Appeal in our law that indicate that the owners of an easement have to maintain it. So those
Sure,
are
I'm just talking about an easement, though. I'm talking about if you specifically contend that these 1986 restrictions require this to be only a golf course. I mean, I mean, even a
Well,
reasonable restriction?
it's coupled with an equitable estoppel argument that I haven't gotten to. If you
Okay, I'll
raised,
get to it.
that's all right. Let me move to that. The
Okay.
Shear case, there were two different issues in it. One was the lake, and they found that the plat justified the existence of an easement in the lake, but there was undeveloped property that had a playground on it. And the court looked at the principles of equitable estoppel. They looked at the conduct of the individual developers and those that were involved to find that there was an equitable estoppel argument coupled with everything else involved, including the plat. So that equitable estoppel was a part of the formulation that they used to be able to assign the owners an easement right in that property, in that undeveloped property. Now, the undeveloped property is really important in our jurisprudence because Judge Tyson wrote in the Friends of Crooked Creek case that, and I would like to quote from that at page 394 of the report, 1917 case, Judge Tyson wrote, while Crooked Creek subdivision may have been contemplated and marketed as a golf course community to induce plaintiffs to purchase lots in the subdivision, no case has recognized an implied easement or restrictive covenants being imposed on undeveloped land based upon statements in marketing materials. And that, I believe, is important because that is factually accurate. That's what the cases say. Here, the property was already developed so that the representations that were made added to and enhanced the fact that you could look out there and you could see 18 holes on a golf course. You could see the clubhouse. You could see the practice area, the putting green. All of that was visible, and that gave meaning to the property owners and communicated a perpetual type of use, that there's a significant investment that's been here. And up to the time that the golf course was shuttered in November, individual defendants were still playing golf and were still paying dues in accordance with that. We have put affidavits in our record that we ask that you look at because these affidavits from purchasers identify what was told to them at the time, among which is the fact that you can play golf as long as you pay dues. We're going to be able to play golf here all the time. Buy my property and you've got the right to play golf or play tennis or whatever you'd like to do from a recreational standpoint. And so also in the Crooked Creek case, I wanted to show a distinction in that case is that not only was it developed, but there was also an affirmative statement in the declaration that stated that the golf course was going to be exempt and free of assessments and liens, but anytime that the golf course use changed so that there were single family or multifamily dwellings that were on the golf course property, that property would be subject to the assessments and liens. We don't have that in that case. We don't have anything clear to that, close to that in our declaration. And so as I am running out of time, I want to say to you that these transfer and waiver documents are significant because after the foreclosure, even of the Hooper Deed of Trust, RF Acquisition gave a transfer approval after it had bought the property. The defendant continued to give. We've got the record with those transfer approvals and releases. We've got them in the record that show that they were done in order to meet the requirements of this 1986 restrictions. They had to give up that right as part of the developer. And so if the 1986 restrictions had been extinguished, why in the world, years after that, were they giving credence to the fact that the 1986 restrictions were being used to give these transfer approvals and releases? And
Mr. Owen, I appreciate your argument, but your time has come to a close, sir.
thank you very much.
Thank you. Appreciate everyone's arguments. Thank you for being with us today.
Thank you very much.
Thank you.
This session of the North Carolina Court of Appeals is now adjourned.